Greetings and salutations. Welcome to another instructional episode of the Legal Beagles. If you notice a little different background back here, I'm visiting the parents, sweetest people you'll ever meet in your life, and I'm thankful to have them. I can tell you, they are hugely supportive and just, like I said, the nicest people you ever meet. But that being said, today we're going to talk about judgments. So let's get into that. Judgments. The paragraph, this is from American jurisprudence, all of it. So it is law of the land. Subparagraph 89, remedies regarding entry of judgment. It is usually within the power of litigating parties to compel the proper officers of a court to perform their duties in regard to the entry of judgments and the making up of a proper record. If a clerk or court refuses to perform the duty in regard to the entry of a judgment, it is proper practice for the judgment creditors to call the fact to the attention of the judge of the court and, by motion or otherwise, invoke his or her aid. If the clerk persists in refusing after being directed by the judge, the clerk is in contempt of court and becomes subject to punishment. This case references is from State versus Starley in the, obviously, the Fifth Circuit. The purpose of entry of a default judgment or default judgment is to, 1, keep the dockets current. 2, expedite the disposal of causes. 3, speed litigation to conclusion and prevent a dilatory defendant from impeding the plaintiff's claim. We've all seen this not be the case. Now, default judgment is entered without regard to the merits of a plaintiff's claim. 1, although some courts state that the presumption that a final judgment disposes of all parties and issues before the court after a trial on the merits does not apply to the default judgments. Other authorities holds a default judgment normally possesses all the attributes of a final judgment. Well, we in our City of Central case, we had a default judgment against the tow truck company that never answered the court. But the Fifth Circuit found that it was time barred and threw all of it out together. Gave away the power of the court. Very strange. And 2, default judgment rules are a means of relief against the delay and neglect of defendants. So the courts distinguish a judgment by default from the mere entry of default. So this is where you send in your affidavit and your default judgment, the clerk can make an entry of default. That is not a judgment. It's entry of default, and you should be able to take that, if no response is garnered from the opposing party, to the court, and they write an order giving you a judgment of default. I think Scirefacias, Scirefacias, the writ of Scirefacias is what you would need to get from the court in order to enforce this entry of default. 1, a default is accomplished at the request of the moving party by mere clerical entry at the expiration of the time allotted for a responsive pleading, while a default judgment, on the other hand, is the final decision of a court of law. 2, a default relates to the issue of liability, and a default judgment occurs after damages have been ascertained. So there's got to be a precise amount of damages that can be awarded in the default judgment. So if you haven't put anything in your complaint and you get a default, then the court's going to have to intervene in order to decide what that judgment is. If you put an amount in the complaint and you get a default, then that amount should be what you're rewarded by the entry of default and the default judgment. But We've seen it go a bunch of different ways at this point. The entry of default does not constitute a judgment. This is what I'm talking about. The clerk just merely looks at the dates and the time, says, okay, they've failed to answer, so they have a default entry. So the clerk would record that. The clerk would mail the opposing party a notice that they're in default and give them an opportunity to respond. I think 30 or 60 days. I can't remember right off the top. I think it's 60 days, but the longer you let it wait, the better. And then I went in for writ of Skyry Faustus, which the court denied because I'm in the Middle District of Louisiana with communist judges, but that is how it's supposed to work. So it's not, doesn't constitute a judgment, but it is rather an order precluding the defaulting party from making any further defense in the case as far as his or her liability is concerned. So they can no longer defend the case. They can only appear and talk about the amount they're supposed to be, or the plaintiff is awarded, right? They can only show up and talk about the amount of damages. They can't defend the case any longer at that point. The default entry is simply an interlocutory order that in itself determines no rights or remedies, whereas the default judgment is a final judgment that terminates the litigation and decides the dispute. So that's what we're talking about. So if the judge signs the order, then that finalizes the judgment and terminates the litigation. Whereas if it's an entry of default by the clerk, it just means that that party can no longer defend the action against the court. They can only show up at the end and talk about how much is to be awarded or argue about what is appropriate in damages. An entry of default and an entry of default judgment are two separate events. What we've been talking about the whole time. One, the first step in the entry of default, when it is shown by affidavit or otherwise that a defending party on a claim has failed to plead or otherwise defend. So you've put in a motion or a complaint and you've given process of service to that party and they don't show up to defend it, then that is an entry of default. And you would show that by an affidavit, which the affidavit has to contain, it has to include that you know that the opposing party is above the age of 18 and legally sound and fit. And the affidavit has to include that it's not away, the entity is not away in military service, which is hilarious what the Middle District did to me when I put my Skyry or Faustus in, writ of Skyry or Faustus in, that Faustus, that I didn't put the affidavit in with the entry of default. And so the judge came back and said, well, you haven't verified that this entity is not serving in the military and is above the age of 18. It was an LLC that got the entry of default, and it was 22 years old. Not that it has to be of age, but even if it would have been required to be 18, it was 22 years old. It was an LLC, so it couldn't be serving in the military, and it couldn't not be of age. So it's a bunch of theatrics went on there, but that's what's required. You have to put in an affidavit saying you know they're not in military service and you know that they're at least 18 years of age of sound and fit mind, so the judge can make a reasonable decision on issuing you the award damages. The second step is the entry of default judgment under some authority, and an entry of default is a prerequisite to the default judgment. So you have to get the clerk to put in an entry of default first, and then you take that entry of default after 30 or 60 days, and you take it to the court, and you ask the judge, hey, with the writ of Skyry Faustus and the affidavit confirming that they're 18 and that they're not in military service and away, etc., that you are entitled to these damages. That's what's required there. And three, however, the entry of the default and the default judgment may be simultaneous and by a single instrument. Oh, I did not realize that. So I guess you can do all of it together. But that's not been my experience for sure. Federal Rules of Civil Procedure provides for entry of default by the clerk. 1. However, nothing in the Federal Rules of Civil Procedure 55 guarantees a party's right to seek setting aside a clerk's entry of default before a default judgment is entered for a failure to defend. Read that again. Nothing in the Federal Rules of Civil Procedure 55 guarantees a party's right to seek setting aside a clerk's entry of default before a default judgment is entered for a failure to defend. So once the clerk's entered a default, looks like you should be entitled to some type of damages, whether it's what you contained in your complaint or what you show in damages to the court in your writ. And 2, a default judgment is an extreme and harsh remedy. And this is why we're going over this, because a lot of people just, someone doesn't answer the complaint, they're past 22 days or 21 days, and you want to run in there and get an entry default. And that's just not how the courts work, because it's an extreme position, and that's what they're going to explain here. Default judgment is an extreme and harsh remedy. Default judgments are not favored by the law and should be avoided when possible. The default judgment should be granted only when strictly authorized and when the party affected should clearly know he or she is subject to default if the party does not act in a required manner. So they need plenty of notice, and in order for the judge to grant this, and they don't prefer it. They would rather everything be settled on the merits. At least that's what the law states, right? But they are very shy in giving away default judgments. 4, although default judgment plays an important role in the maintenance of an orderly, efficient judicial system, as a weapon for enforcing compliance with the rules of procedure and for facilitating the speedy determination of litigation, courts generally favor the disposition of litigation on the merits rather than default judgment, as we just talked about. Now, default judgments continue. Okay. When ruling on a motion for a default judgment, a trial court must balance the need for an efficient judicial system with the judicial preference for deciding disputes on the merits. So has it been egregious? Are they just one day past the deadline? Or has it been a year and they haven't answered, and you've sent them multiple notices, the court sent them a notice, and they just refuse to answer? Like in my case, I should have gotten a default judgment. I did not. However, burdened trial courts may be, they must be, however burdened the trial courts may be, they must vigilantly attend to their duty in connection with the default process to act as a gatekeeper, ensuring that only the appropriate claims get through. So the judge is going to have large discretion here on what to do. Look at the facts, you're going to look at your affidavit, you're going to look at the time that they've not answered, and then they're going to decide. Accordingly, all doubt should be resolved in favor of allowing a trial upon the merits and in favor of a party seeking relief from a default judgment. So they're going to favor the litigation. They're not going to just run to the default judgment. You're going to need a real good reason to get a default judgment. Just keep this in mind. This is not 2 days later, let's run and get a default judgment. Not going to work like that. Thus, courts hold that it should be used only when other enforcement powers fail to advance the litigation. So you're going to have good reason. Have to lay it out for the court. Show them why that they should grant you this default judgment. Default is not appropriate when the plaintiff knows that a defendant is represented by counsel. So if you know that they've retained counsel and are planning to defend this, don't run to the court with a default judgment. It's going to make them mad. Don't do it. Don't do it. Indeed, there is authority that when a lawyer knows the identity of a lawyer representing an opposing party, he or she should not take advantage of the lawyer by causing any default or dismissal to be entered without first inquiring about the opposing lawyer's intention to proceed. need to investigate this, contact the opposing party, and if they don't answer or they refuse to defend the claim, then you can go forward with a default judgment. Generally, entry of default judgment lies within the discretion of the court. Keep in mind, you got to have a solid reason here. Court has considerable discretion because of the drastic nature of a default. Like we talked about earlier, it's a harsh remedy for people that just didn't respond or missed the deadline by a couple of days. When ruling on a motion for default judgment, the court has broad discretion and must be exercised liberally, lest technicality triumph over justice. Well, that's all nice said and good there, but we see technicality triumph over justice quite a bit these days, and that's a testament to our judiciary and the quality of judges that we've allowed Congress to put on the bench and our state to be elected thereof. 2, in exercising its discretion, a court must weigh the preference for disposition upon the merits against the counterbalancing considerations of social goals, justice, and expediency. Wouldn't it be nice if they really considered those issues before moving forward on rulings and orders and things of that nature? This is how it's supposed to be, folks. This is how you hold them accountable. 3, nonetheless, a federal court does not abuse its discretion if the judge finds that the docket conditions require a rigorous application of the federal rule allowing for default judgments. So what this is saying here is if the court docket is stacked up and they need to dispose of these cases, and this lawyer or this opposing party is wasting all the time in the court and it's just taking up spots on the docket, they can use a rigorous, like they said, they're broad discretion. They can use a rigorous application of this FRCP rule to rid the court of these dockets. If no one wants to participate in the court, give them a default, get them out of the court system. So the busier the court, the more likely to get a default judgment, which we're seeing the dockets increase a lot after these COVID things. So the court's going to get bunched up. So maybe these default judges become more and more frequent. Hopefully, we'll see for these lazy lawyers. Otherwise, broad discretion is given to the judges applying this non-preferred method. So do not use it as a weapon. Simply use it to speed delay, right? Factors the court considers for default judgment. These are the factors they consider. 1, the sums of money potentially involved. So if you're asking for $800 million, you're probably not going to get the default judgment. If you're asking for $15,000, well, might be more reasonable for the judge to grant. 2, whether material issues of fact are involved. So if there are conflicting factors the judge knows about, and we know that someone's in the hospital and can't respond, or something of this nature, some emergency has happened, then perhaps the judge is going to factor these things in. 3, whether the grounds for default are clearly established or in doubt. So did you provide your affidavit? Did you give the judge and the court a good reason for getting this default entry? Whether the default is largely technical. So the court are supposed to prefer litigation on the merits rather than technicalities. Well, they're supposed to give the pro se's the benefit of the doubt. Well, lots of times we see these technicalities taking the reins of the judiciary to defeat the people they don't want in there, or the causes of action they don't want to respond to or have to answer, right? I mean the courts, not the opposing parties. 5, whether the default was due to excusable neglect. So did they not get the process of service? Did they have some type of emergency? Were they in military service? Were they out of the country? Whatever. These are, I would think, excusable neglect. Whether there is evidence of willfulness on the defaulting defendant's part. So in my City of Central case, as we said, they willfully defied the court's summons, court's notice of default. I sent them a copy of everything up until the point that we started litigation. I sent them a copy of the appeal. They did not ever respond word one to the court, yet the court let them off the hook for the same reasons the people that defended the litigation said that it was time barred. Whether it was or not, there's a lot of back and forth, but this is what this is talking about here. Whether the plaintiff has been prejudiced. So if there's a huge delay and the plaintiff's been prejudiced, then there might lean more in favor of granting the entry of default for the plaintiff. So this goes back to having to give them reasons. Be sound and logical when you bring these arguments. If you make a good case, you should get a default judgment. And these factors continued here. 8, the relative hardship on the parties arising from a default or refusal of the court to default. So it's going to look at the hardship for the plaintiff side. It's going to look at the hardship on the defense side and decide that if there are factors that weigh in one way or the other, it may sway the court one way or the other. The culpability of the party subject to defaults. So how guilty are they? How obvious that it is that they're not responding and with willful neglect. The existence of meritorious defense. So if they have no facts on the record, they've answered no complaints, then you're probably going to get it for the plaintiff, right? Probably. Probably. 11, the merits of a plaintiff's substantive claim. So they're going to look at the complaint. Have you stated a real claim that the court can grant relief for? And if you have enough facts in your complaint and you've made it airtight, more likely to get the entry of default. The sufficiency of the complaint, same along the same lines here. How diligent were you in preparing your complaint, or did you just throw down, hey, Johnny wronged me? Well, that's probably not going to get you very far. The strong policy favoring a decision on the merits. So in a way against, like, you're going to have strong evidence for the plaintiff. Overcome the merits of the case. In fact, there is a marked judicial deference for deciding disputes on their merits and for giving parties their day in court, especially in cases involving material issues of fact, substantial amounts of money, weighty policy determinations, or when important rights are at stake and there has been a lack of adequate notice to the party. So I think that's pretty self-explanatory. I mean, sometimes the court's not going to want to get into these weighty policy determinations, as in our U.S. Marshals case, and they're gonna try to delay. They'll never give us a default entry there, even if the party's defaulted, which they haven't. But so all of these factors are going to come into play before the court decides that there's a quote-unquote controversy before them that they have to decide. So this gives them a lot of outs. All the more reason you need to make sure it's airtight, which only comes with study. To be considered, the prejudice must be alleged by the movements. This is where we're getting back to, being detailed, logical, giving the court good reasons. And appeal courts look for abuse of discretion on the judge's part. The standard of review on appeal from a default judgment is for abuse of discretion. So if the judge made some abuse of discretion when he issued or denied the default judgment, then that's what the appeal court looks for. Again, the Fifth Circuit didn't find any abuse of discretion by not penalizing the people that never answered the complaint. It's a mystery to all of us. An appellate court also reviews a trial court's denial of a motion to lift a default judgment for abuse of discretion. So it's same. So whether they granted it or they denied it, the appeal court's supposed to look at the entire review, de novo. According to some courts, mandamus is the proper vehicle for challenging a trial court's refusal to enter a default judgment, because such a refusal is not a final judgment, which is a requisite for an appeal as of right. Writ of mandamus. On a petition for writ of mandamus, the petitioner must show a clear abuse of discretion to warrant an appellate court's ordering the entry of default judgment. So there we are as far as default judgments go in the writ of mandamus. Like I said, we're not getting very far into this, but just a side note there. Default is an appropriate sanction. When a defendant shows a pattern of deliberate delay or a lack of diligence and has ignored the court's commands or treated them with indifference. Well, so if the court orders you to answer discovery and you don't, or etc., there's, could be a default judgment involved. When the court says something, you should do it, or they're going to penalize you. At least that's what traditional law says, right? We know that these judges are members of bars, and they kind of bring their brotherhood in and help them out, but this is how it's supposed to work. For repeated violation of the court's orders and continuous disregard for the court's authorities, default would be appropriate for this, an appropriate sanction for this. 3, when a director or managing agent of a party fails to appear at a pretrial or settlement conference after having been ordered to attend, default would be an appropriate sanction. When a party's conduct includes willful violations of court rules, contumacious conduct, or intentional delays, default is an appropriate sanction. When a defendant fails to appear, answer, plead, or otherwise defend, default. Again, need good reason. It can't just be one day past the deadline. As a sanction, when the defendants failed to obey a pretrial order and failed to demonstrate a reasonable diligence in keeping track of the progress of the lawsuit. Attorneys fall behind, they quit communicating, default. On the other hand, default judgment is not an appropriate sanction for marginal failure to comply with time requirements. So this is what we're talking about. A day or two, one thing. If you're, for instance, if you're in discovery and you have a trial deadline coming up and, they're dragging this out for a couple, 3 weeks, and that's time you need to conduct depositions, then default would be appropriate. If they're 2 days late and they've told you that, hey, well, I'm sorry, but we're gonna comply with this. It's just gonna be, it's coming, right? Then you wouldn't want to run to the court. It's gonna make them mad. Please, try to resolve things with the opposing party first. When they refuse or they are obstinate in their conferral with you, their sincere conferral with you, then that's when you run to the court. Default judgments. Pleading and appearance distinguished. Some authority holds that in the strict sense, a default judgment is one taken against a defendant who, having been duly summoned in an action, fails to enter an appearance in time. Though the term is also now ordinarily applied where default occurs after an appearance as well as before, and may be rendered where a defendant fails to answer or plead. Just kind of repeated what we've been talking about. Under other authority, a timely appearance alone does not prevent a judgment by default for failure to file a pleading. So just because they came and appeared and want to talk about these other issues and they haven't filed a pleading, if they keep delaying, then you have good cause to go to the judge and say, hey, we want a default judgment against this guy. He is delaying the proceedings and he's purposely not answering the complaint. Still, other authority merges the concepts of appearing and answering by stating that a default judgment may be awarded when a defendant fails to make an appearance by filing an answer or otherwise defending an action. Another court holds that a default and failure to appear are two different events, so that a party who has filed a responsive pleading is not in default even upon failure to appear in the court. So they're talking about all the different circuits, first first, second, third, fourth, fifth, etc. And they have different rules. So you're going to have to go into the case law and see how they've ruled on default judgments and see if your situation is applicable to running to the court to ask for a default judgment or not. Again, you don't want to make the judge mad by running in there and whining when you could have just called the opposing attorney and he said, oh, it's coming tomorrow. And, you can point that out. You can try to sanction him if you want, but that's a private thing between you and the attorneys until he refuses to answer, right? So what it means to otherwise defend. So this is going to explain to us what it means, like when you retain a lawyer. It looks like you're planning to defend, but it doesn't always mean. So this is going to define some nuance here. Generally, for the purpose of a default judgment, a failure to plead or otherwise defend occurs when a party fails to file a timely answer or otherwise respond to a complaint. Generally. In a statute providing for a default, if a defendant fails to plead or otherwise defend, the term otherwise defends encompasses a motion directed to the sufficiency of the complaint. So 12B motion, for instance, is sufficient to say you're going to defend, even though it's not an answer to the complaint. So be aware, if they're defending the case, no matter what, you're going to have good reason why they're not responding. Filing a motion to dismiss constitutes defending an action and will prevent entry of a default judgment even if filed late. How late? I guess it's going to depend on the circuit. It's going to depend on the judge. Read your case law. The words otherwise defend also refer to attacks on the service or motions to dismiss. So this is like when you come into traffic court and you make a special appearance, right? You're defending it, but you're not actually appearing in the court. So. Or for better particulars and the like, which may prevent default without presently pleading to the merits. So they can come in and say, the lawyer can come in and notice the court he's going to be defending, but not actually enter anything that qualifies as defend. But he's going to talk about service. If you didn't serve the party properly, then that lawyer can come in and talk about service, a process before jurisdiction is granted over the party, and so that service is required for jurisdiction. So the attorney can come in and argue that without actually muddying the waters too much, and he's defending it, but he hasn't answered the complaint, and until that issue is solved in jurisdiction, then your 21-day complaint timeline means nothing, right, if you haven't served them properly. By filing a reply to a plaintiff's motion for default judgment, in which the defendant alleges that the trial court lacks personal jurisdiction over him, which we just talked about, over him or her an invalid service of process, the defendant otherwise defended against the complaint and thus does not default. So serve them properly, make sure you got everything airtight. On the other hand, so apparently, this is a great controversy between circuit courts. You're going to have to read your case law. A motion for extension of time does not constitute an answer sufficient to preclude a default judgment. Interesting. A motion for summary judgment is not a pleading, nor is it mentioned among the motions which preclude entry of a default judgment. When a claimant answered the government's complaint without a verified statement required by the rule governing certain admiralty and maritime claims, the claimant fails to otherwise defend. A defendant's motion to transfer venue is not otherwise defending against a claim, and therefore does not preclude the entry of a default judgment against the defendant, where the motion is not a pleading, and the motion does nothing more than indicate the defendant's intent to defend against the plaintiff's claim at a later date in a different county. So this would be applicable to Brandon's Wildlife Fisheries. Although he never filed his default motion, he should have after reading this right here. Some authority holds that a failure to appear for trial does not constitute a failure to otherwise defend by a party that has filed an answer. Filing an answer, filing a 12B6 motion, yes. Filing a change of venue, no. Keep in mind, default, I'm not sure how to say this, nihil dicit, I believe. Under some authority, default nihil dicit is a default for failure to file a responsive pleading within the time allowed after service of a summons, answering the complaint. Thus, a judgment rendered against a defendant who appears but does not file an answer is not a default judgment, but a judgment nihil dicit. So there's a distinction, but under other authority, a nihil dicit default judgment is limited to situations where the defendant has entered some plea, usually of a dilatory nature, but the plea fails to place the merits of the plaintiff's case in issue. Judges. Subsection 16, removal of judge from office generally. United States judges, including district judges, are subject to removal only by the Senate of the United States sitting as a court of impeachment. So the U.S. House of Representatives would have to impeach him. The Senate would have to hold a trial and remove him from office. Nature of proceedings to remove a judge. Charges against a judge need not be established by proof beyond a reasonable doubt, but rather by preponderance of the evidence or by clear and convincing evidence. For instance, a cognizable misconduct complaint based on allegations of a judge not following prevailing law or the directions of a court of appeals in particular cases must identify clear and convincing evidence of willfulness, that is, clear and convincing evidence of a judge's arbitrary and intentional departure from prevailing law based on the judge's disagreement with or willful indifference to that law. But what it doesn't say here is you also have to convince all the members or half the members of the House of Representatives to agree with that evidence in order to send it to the Senate. And then you'd have to convince the Senate to remove one of their buddy judges. So I don't think this is something that's going to be happening anytime soon until the people really demand it. But you never know. Hey, things change all the time. Events change the perspective of the people quickly. So anything could happen moving forward at any time. But for now, I just don't see this as a case. The speaker would have to bring it up. So you have to convince the speaker, half the members of the House, and then half the members of the Senate to convict him. Before reporting findings of fact to the Supreme Court, Judicial Qualifications Commission, JQC, must conclude that they are established by clear and convincing evidence. The Supreme Court must then review the findings and determine whether they meet this quantum of proof, a standard which requires more proof than a preponderance of the evidence, but less than, beyond, and to the exclusion of a reasonable doubt. So there's three levels. Preponderance of evidence is a low standard. They talked about this in the Fannie Willis case. And then there's a clear and unreasonable doubt. That's the highest standard. So, and then there's one other in between, and that's where this is. That's where this falls. Findings and proceedings before the JQC that meet the clear and convincing evidence, the medium standard, are given great weight by the Supreme Court. Grounds for removal of a judge. Grounds for removal of a judge from office are usually prescribed by the constitutions or statutes of the various states or by the applicable state codes of judicial conduct. Among the common grounds for removal of a judge from office are willful neglect of duty, corruption in office, intemperance to such an extent as makes the judge unfit for the discharge of official duties, incompetency, misconduct, violations of a judicial canon requiring that judges avoid impropriety and the appearance of impropriety, or the commission of any offense involving moral turpitude while in office or under color of office, which I would imagine is, maybe investing in a vaccine company and then, ruling on court cases that involve these issues. I mean, we've seen that, right? But these are the standards you would be required to bring to Congress in order to even have a chance to get it done. On the other hand, if error in following the law were willful, it could fall into either the egregious or bad faith categories, particularly if it impacted fundamental rights clearly and unmistakably known to every competent jurist, such that their violation brings the judicial process into public disrepute. This is exactly what Judge Shelley D. Dick has done in the Middle District of Louisiana. It has violated both the Louisiana Constitution with access to courts, and it has violated our constitutional fundamental rights to redress the court for grievances and have access to the courthouse. And she has done this not under an official in an official action in a court proceeding where she would have jurisdiction and judicial immunity. She has done this outside of her office and her administrative duty, and it has affected the public to a point of disrepute. She should be removed from office without a doubt. But we are still waiting for the motions to dismiss, which have been finalized for over a year now. And Judge Maurice Hicks up in Shreveport has decided to sit on it. So here we are, waiting on an order so we can at least appeal it, but let's continue, and I digress. Sorry. And that concludes our episode on default judgments. Please let us know in the comments how you enjoyed it, if you thought it was thorough enough, and what other topics you want to see in the future, and I will try to put them together and put them out. In the meantime, have a great day, and we'll see you soon.